afternoon. It was clear after the November 5th election that the election of Donald Trump was going to have enormous ramifications for virtually every area of law. So we did a panel the next week, 6 faculty members, to speak with our community about what in general is the Trump election going to mean for the law. And I promised at that time that what we'd do is a series of panels starting early in the spring semester on what the Trump election will mean in these specific fields. The goal, of course, is to provide information, but also for those who disagree, a sense of how do we go about fighting back with regard to these changes. And whatever I could have anticipated, whatever we could have anticipated with regard to the change in the law, I don't think any of us have ever seen how quickly so much has happened in just the first week of the Trump presidency. So together with the Christopher Edley Jr. Center on Law and Democracy, we're providing a series of programs. This is on the Trump administration and the environment. It's next week there's going to be one on Trump administration and immigration. The next one is going to be on Trump administration and the federal workforce. Then there's going to be one on Trump administration and reproductive justice. And we'll continue this series through the semester so long as there's interest. I'm going to turn this over. I'll introduce my colleagues real quickly, and then I'm going to turn it over to them, the experts with regard to the environment. Dan Farber is going to moderate this panel. Sharon Jacobs is to my far left. Eric Biber, Holly Doremus, our terrific faculty who specialize in environmental law. And with that, I'm going to sit down and listen.
Well, great. Thank you, Erwin. I'm going to begin with a quick summary of Trump's executive orders and some of the early actions that the administration has taken. And after giving some background, then I'll be asking some questions of the other panelists, and we'll see how the conversation develops from there. So we knew from Trump's first term something about what he was likely to do this time around. And what we saw then was a very systematic effort to repeal Obama administration environmental regulations, and particularly to eliminate anything relating to climate change. Trump gave every indication during the campaign that he planned to repeat that performance. And so at least some of what has happened since then is definitely not a surprise. Although, as the dean just said, I think there were some surprises nonetheless. So Trump began the process with a bang last week with a whole slew of executive orders. And some of those executive orders, especially the big one on energy, have a whole bunch of moving parts. They really could have been, really could have been issued as 5 or more separate executive orders instead of being packaged as one. So there's a huge amount of stuff to think about. I was saying before the panel that I have trouble remembering anything before last Monday. It's sort of so dominating the attention, which is, of course, one of the goals, I'm sure, behind the timing of the executive orders. So let me just highlight some of the major features of those executive orders. I'll spend a little bit more time talking about some of them because I'm not sure they're important, but I'm not sure whether they'll come up later in the conversation. So first thing he did was overturn a long list of previous executive orders, which included pretty much anything that Biden had issued relating to the environment or climate change. And I'm not less sure about this, but maybe everything that Biden had done in terms of energy, too. Sharon Jacobs would know more about that than I do. So he starts out with a long list of executive orders that are being repealed. And then he directed agencies to begin action on the regulatory front. So, for example, he directed EPA to begin the process of repealing Biden-era regulations, such as limits on greenhouse gases from vehicles, and trucks and power plants, right? Now, those were some of the most significant of the Biden regulations, but there were a bunch more of them in different parts of the government. Trump ordered a lot of agency action to repeal those regulations. Now, those of you who have taken either environmental law or administrative law know that passing a regulation can be a very arduous process for an agency. It has to put forward a proposal, which generally contains a very lengthy preface explaining the data and legal reasoning behind the proposal. There is then a comment period, and the agency is required by the APA then, when they issue their final version, to respond to major comments and explain whether they found the comments persuasive. If not, why not? If so, how was the regulation changed in response? These days, the agency often has a separate document called Response to Comments, and that can be very extensive. I think on one recent Biden rule, there was something like 900 pages of responses to comments issued at the same time as the rule itself. So there will be some period of time, maybe a significant amount of time, before anything actually comes out of the agencies on many of these rules. But the process has begun. One of the things I think we will talk about a bit today is Trump's declaration of a national climate emergency. What am I saying? Freudian slip. A national energy emergency that is based, not clear entirely what it's based on, to be candid, but at least in part on the idea that the development of artificial intelligence will require a huge amount of reliable new energy sources, and that this could overstress the grid, and failure to develop these energy sources might affect national security. Experts, well, no, I'm not going to say any more about that. I'll leave that to our energy expert on the panel. But at least there was some grounds for skepticism about the reality of the emergency that Trump claimed. So that's kind of a general overview. I'm leaving out a ton of things, but I want to mention three things in a little more detail. So one of the things that Trump did immediately was to withdraw the U.S. from the Paris Agreement. Now, actually, the agreement requires a one-year waiting period. Trump ignored that and simply withdrew announced that the U.S. would no longer feel bound in any way by the agreement immediately. We don't know yet what effect that will have on international negotiations. Obviously, the U.S. will not be participating in those negotiations, but we don't know for sure how other countries might react. At least as of yet, nobody has followed suit. I saw some speculation about Argentina as a country under a sort of somewhat Trump-like figure that might follow suit, but so far nobody has. But we don't know, for example, whether China will react by sort of slackening in their climate change efforts, or whether they will view this as an opportunity to raise their international profile by taking more vigorous action on climate change and sort of play up the contrast between themselves and the U.S. Second, and this one I think did not get nearly as much attention from the press, There was orders, actually more than one, I think, abolishing DEI, diversity, equity, and inclusion programs within the federal government, and threatening to take action against those in the private sector, and that got noted by the media. But at the same time as that, Trump first closed all environmental justice offices within the federal government. And then in a little bit later order, I think maybe 2 days later, he repealed not just Biden's orders relating to environmental justice, but went all the way back to an order by Bill Clinton that's been the sort of foundation of environmental justice efforts in the executive branch. Now, that was one of those things that I think was not expected because he didn't criticize that executive order or take any action against it in his first administration, but it didn't survive the second administration. And I think one of the signs of the difference here and on some other issues is that first time around he was mostly focused on undoing what Obama did, and this time around, at least on some issues, he seems to want to go back further. He also repealed an executive order Jimmy Carter had signed about environmental impact statements in NEPA, right? So clearly willing to go, and he repealed an employment discrimination order issued by LBJ in the 1960s. So, you know, he's digging deeper in his efforts. I don't, you know, it's not clear what on the ground impact the repeal of the EJ order has. There have been complaints that the EJ provisions were not sufficiently, or in some cases maybe really at all adequately enforced. But there's clearly a statement here that the administration views these orders with suspicion, believes that they involve illegal discrimination on behalf of minorities. That's clear from the way it's labeled. So at least a sort of battle line has been drawn. And then the final thing I wanted to talk about is a portion of the executive order appointing some advisors and asking them to report back on EPA's finding that greenhouse gases endanger human health and welfare. Now, this was something that sort of the more extreme anti-climate groups had wanted in his first administration, but they didn't do it. It may well be that this is just a sop that's being thrown them and that, in fact, nothing will happen here. But on the other hand, it's quite possible that they will make a serious effort of some kind to sort of make climate denial official government policy. I'm kind of inclined to think it was more a political move than anything else, but time will tell. Okay, so all that happened in week one, basically. I want to turn to our panelists now for their thoughts about some of the developments in the administration. And let me start with Professor Jacobs. So you've written before about the potential use of sort of attacks on agencies rather than on regulations as a way of de facto deregulation. I wanted to start by asking you about that and what you see happening in that regard.
Sure, thanks, Dan, and thank you, Erwin, for bringing us together today. I almost felt like I should dress up in some really silly costume just because this administration's first week in office and kind of the blitz of executive orders that they've issued has not felt like business as usual. In some ways, it has been, right? It's come dressed as business as usual in that sort of the form of executive orders is something that we've seen, virtually all presidents do. And so the trappings look typical, but the way that this administration has issued those orders, with the pomp and circumstance of signing them in an arena at a rally, right, throwing the pens to the crowd afterwards, the sort of sheer number that were issued in the first 24 hours, and the content of these executive orders, the way that they've pushed sort of the boundaries of existing law. Again, not totally new. We've seen presidents using executive orders to push the boundaries of existing authority for quite some time now, but the sort of extent of it in this administration really, to me, felt surprising. So there was something that felt a little odd to me about kind of just doing a pen on executive orders. I mean, the fact that we're doing this maybe is some reflection of the seriousness, I think, with which we should take this and try to get our minds around what's happening. So to Dan's invitation, I did want to say, before we kind of get into the substance of the environmental and energy impacts, I wanted to say something about this idea of remaking federal agencies, because environmental law, energy law at the federal level is made through executive agencies. There's relatively little that the president can do on his or her own here. So we need executive agencies, we need independent commissions to be staffed well enough, to be resourced well enough to actually put into implementation the laws that Congress passes. Otherwise, those laws don't get implemented to the same extent. So that's why I think it's really important to keep an eye on kind of what do those agencies look like, what is their kind of health, right? So there are a number of executive orders that addressed this. We know that President Trump, he's been very vocal about this. We know that he is highly suspicious of a lot of the people who work for the federal government, who staff these agencies. He's referred to them as the deep state, at least some of them, and the idea is that those who are not on board with his agenda are somehow working against him, right, and that's a threat to the implementation of policy in the executive branch. We also know, right, that a goal coming in was to shrink the size of the federal government, right? So how can a president, as opposed to Congress, which creates these agencies in the first instance, do that? Well, we got some flavor of that in the executive order. So first, the establishment of DOGE, right? The Department of Government Efficiency, not a department, that is this was actually quite clever. I saw an article refer to this as administrative jujitsu. The president actually took an established division, the U.S. Digital Service, and just renamed it the Department of Government Efficiency, and gave them advisory powers to maximize governmental efficiency and productivity. This, of course, is not an agency staffed by Elon Musk, right, as the head. They've already been incredibly efficient and cut out 50% of their leadership. So Vivek Ramaswamy is no longer the co-leader of DOGE. He is now running for the governor of Ohio instead. This is a set of individuals who are tasked with advising the government about how to kind of cut agencies down, how to do things with fewer resources. So we'll have to see what comes out of that office. Another move that came out the first day that surprised me, maybe didn't surprise others, was the elimination of remote work for federal workers at federal agencies. So some of my friends who work in the federal government were surprised by this. And remote work has been an option since the pandemic, in some cases going back further. Many people have designed their lives around that remote work. So that sort of instant putting a stop to remote work meant that people in the federal government have to think, can I continue to do this job, or do I have to leave this position? And, if we're thinking about this from a strategic perspective, maybe that's not unintentional, right? Maybe the idea is we try to sort of clear the numbers out of the federal workforce by getting people to resign, and then either we have a leaner federal workforce, or those people can be replaced. And so that is another thing he did. Re-implemented Schedule F, which was an order that he'd issued at the end of his previous term, which reclassifies a significant number of federal employees in a way that strips them of job protections. And so that means that those employees can be more easily terminated at will, essentially. And so that, again, gives the president more control over the composition of the bureaucracy. The reassignment and replacement of senior executive service members is sort of the top level of the civil service, right under the federal political appointees. These are the most experienced members generally of agencies. They have always had less job protection than kind of the basic civil service, but the process has already started to reclassify some of those positions. One example I was just reading about was that several top members of the civil service in the Department of Justice, Environmental and Natural Resources Division have been reassigned from their units to a special task force looking at ways to bring lawsuits against sanctuary cities. Like some of the cities in California that have refused to cooperate with federal immigration authorities in particular ways. So, that's again puts those individuals in the position of, do I continue to do this job, right? And maybe not unintentional. A regulatory freeze, right? So this is the idea that no new rules can come out for an undetermined period of time. Again, this is not unusual. We've seen this in the past. Presidents are trying to get their feet under them. But you sort of put it together with all these others, and it looks like maybe something a little bigger. No rules or directives until the department head reviews and approves them. A hiring freeze. Right? So people may be leaving their positions in the federal government. There is a hiring freeze right now with a few exceptions for the military, for immigration enforcement, public safety, national security. And the director of the Office of Management and Budget in the executive branch has been told within 90 days to issue a plan to reduce the size of the government workforce through efficiency improvements and attrition, right? So that when people leave, they are not replaced. That is sort of the flavor of that. And then finally, just the last one I want to mention, is this order saying there shall be no hiring based on race, sex, or religion, but also no hiring of individuals who are unwilling to defend the Constitution, right, or to faithfully serve the executive branch. And I think it behooves us to think about, what that actually means to this administration, right? Serve the Constitution seems pretty straightforward. That's something that we ask of people who serve in the federal government. Faithfully serve the executive branch. What does it mean, right, to faithfully serve the executive branch? Or we offer a lot of courses on ethics, what it means in the context of different types of lawyering jobs. Faithful service, right? To whom do you owe your faith, right? Is it to the Constitution? Is it to the executive branch? What happens when those two things conflict? Just sort of interesting to push on and think about there. But I think collectively, we could think of this as part and parcel of what a co-author, Jody Freeman, and I called in 2021 structural deregulation, a kind of undermining of the infrastructure of the federal government. You could also say, right, of making the government more efficient, right? I'm sure that's how the president would characterize it, so I have a slightly different view. But could be part and parcel of this undermining, which both could make it harder to implement the laws that Congress passes, but also, right, and this is something Dan, I think, has thought about a lot, can make it much harder to actually implement some of the deregulatory measures that this administration might want to take on, like the repeal and replacement of notice and comment rules. So I'll stop there.
Okay, great. I had a sort of follow-up question, sort of changing, asking you to change hats for the moment to energy law expert. What do you see happening in that area? Do you think that Trump will be able to make major changes in the way the energy system functions, or in energy law more generally?
So I think maybe I'll give you kind of my view of this, and others on the panel may have views about, how slightly different views about how much we're actually going to see a shift in the energy sector. But there were several administrative orders and there are several plans in place that aim at least to reshape the energy system that President Biden envisioned, certainly, and that might, I think, at least set us back in terms of the transition to lower carbon, lower polluting energy sources, even if they can't ultimately change the direction of industry. So the first thing I wanted to return to something that Dan opened with about the declaration of a national energy emergency. This was one of the things where when I was listening to the inaugural address with my son on our little iPad in the morning of last Monday, and he declared national energy emergency, that's one of the ones where I I did a double take, and my son goes, "What's a national energy emergency?" And I said, "You know what? I don't know." So we're sort of trying to work through this. National energy emergency could mean a number of different things, and if you parse the executive order, it looks like it does mean a series of different things. Sort of like, where does this authority to declare national emergencies come from, right? I suppose there's some argument, there's some inherent authority in Article 2 of the Constitution, but there is actually a statute that allows the president to make these declarations of national emergency as long as there are statutes that say X, Y, and Z follows. When there's a declaration of national emergency, there's a statute that says it's for the president to make that determination. And there is something called the National Emergencies Act, which was actually put in place to constrain presidential emergency authority and make sure that we didn't have national emergencies kind of sitting out there forever without re-examination, that limited the duration of those emergencies, required the president to submit any national emergency declaration to Congress and publish it in the Federal Register immediately, right? So there's notice of these declarations. What happens when there is a declaration of national emergency is that it essentially is like a domino, right? And it triggers the dominoes in a variety of other statutes that are on the books that contain provisions that say, in case of a national emergency, X authorities are available to the president, to other actors. And so we have a large number of statutes like that. The Brennan Center has, I think, a pretty good comprehensive list of those statutes. There are over 100 of them that the Brennan administration cites. And so this declaration opens up possibilities under those statutes, some of which require further findings, some of which do not. And so, for example, under those other statutes, there are provisions of the Clean Air Act that can be waived so that emissions restrictions won't apply, and there are lots and lots of other examples there. So it just opens up possibilities for the president, but it does not, and I think this is worth underlining, does not, as President Trump seemed to suggest upon signing the executive order, mean you can do whatever you have to do to get out of that problem. So that is not anywhere in any of the statutes, and that is not what the declaration means. That statute, I won't go on at length, but that statute, that executive order did a number of other things with respect to energy, or purported to do a number of other things, directed agency heads to identify and exercise existing authorities available to them to facilitate leasing, siting, production, transportation, refining, generation of domestic energy resources. And really interestingly to me, anyone who's taken a class with me will know that I frequently suggest that you read statutory and regulatory definition sections first, redefines energy for purposes of this executive order to mean crude oil, natural gas, least condensates, natural gas liquids, refined petroleum products, uranium, coal, biofuels, geothermal heat, the kinetic movement of flowing water, and critical minerals. What's not on that list, right? Wind, solar, energy storage. The big ones where we've seen just unbelievable decline in prices over the last decade or so, 80%, 90% decline in prices, where these are the technologies that are really taking off and that make up the vast majority of new capacity additions in the United States. So lots of kind of subsidiary orders to different agencies to try to do what they can to bolster the kinds of fuel production identified in that definition section. Last thing I'll say there is just this idea, and Dan sort of teed this up, this idea of, well, are we in an energy emergency, right? What does it take? What is the threshold at which we've reached an energy emergency? Because there's no kind of clear statute here that defines that, it's not really obvious when we're in it. I would argue there's just a lot of reports coming out of the federal regulators responsible for reliability on the energy grid, state regulators and local regulators responsible for making sure there are adequate supplies of energy in the United States, none of which seem to suggest that we are anywhere close to a national emergency when it comes to energy supply. We are producing more oil and gas than ever before in the United States. There are a few reports that have come out of federal regulators that take a long look ahead and say, here are some areas where we want to make sure we have sufficient capacity additions to avoid, right, the possibility of, in an extreme weather event, having a limited blackout, for example, making sure we have enough new transmission here and there. Those are forward-looking, those are planning documents. None of them say, we're in a crisis right now. Right? So I think there's a real question about whether the evidence supports the idea that there's a national energy emergency. And I'll turn things back over to Dan. I'll just sort of list 2 or 3 last executive orders. We can talk about them in the Q&A if you like. One of them has to do with the immediate pause of disbursement of funds under the Inflation Reduction Act, President Biden's signature piece of climate legislation. Most of those funds had been obligated by the previous administration, which means they cannot be clawed back. So a lot of that money is out there. A lot of the money, moreover, for renewable energy and energy efficiency and electric vehicles actually comes from the tax credit side of the program. So that's not something you can undo with the stroke of a pen. That's written into the law, at least for now. That's something that was clearly part of the agenda. And then kind of reversing restrictions on oil and gas extraction and adding in new restrictions on offshore wind development on the outer continental shelf, and I'll defer to my clients that have, or my colleagues that have more expertise in natural resources here, but it's not clear that there's legal authority to do that.
Okay, great. So we've been talking up to now about the sort of administrative agency side of things, but of course, in the world of policy making, the executive branch and agency action are important, but so are politics, and so is Congress, or state legislatures in the case of states. Professor Biber has done a lot of thinking about sort of the political dynamics surrounding energy and the energy transition. I guess one immediate problem is whether the administration will succeed in repealing the Inflation Reduction Act, which is one of Trump's stated aims. Obviously, predictions are hard, especially about the future, as somebody once said. But what's your take on that?
Yeah, thanks, Dan. So I'll sort of go big picture in thinking about legislative changes and the possibility of legislative changes, and I'm going to restrict myself to federal legislation over the next 4 years. One could look at a lot of other things that could be important. And as Dan indicated, politics is uncertain. Strange things will happen. I think the best prediction you can always make is that you will be surprised by something over the next 2 to 4 years. So that being said, I think the baseline here is it's unlikely that there's going to be significant legislative changes to the basic environmental laws in the U.S. over the next 4 years. I'll start with looking at the first 2 years and then look at the 2 years after that. And so the reason I have that baseline understanding of what's likely to happen is based on the sort of state of play in both the U.S. House and the Senate. So in the House, the Republicans have a very narrow legislative majority. Based on the election results, it was 220 to 215. There are currently 2 Republican vacancies because of resignations. 1 more Republican seat will be vacant, assuming Elise Stefanik gets confirmed to be UN ambassador. Those vacancies will be filled in the next coming months, almost certainly by Republicans, but that is still an extremely narrow majority, and I'll talk about those implications in a second. In the Senate, the Republicans gained 4 seats, so they're up to 53 seats. That is still well short of the 60-seat threshold required to break a filibuster, which under Senate rules is required for enactment to be a threshold required to meet for most substantive legislation. And 3 of the seats that were picked up were more moderate Democrats or independents. It was mentioned from West Virginia, Tester from Montana, and Brown from Ohio. So I don't think you saw some important swings in policy preferences there, but not as much as might have occurred. And so the implications of those narrow majorities, so unless there's a decision to eliminate the filibuster by changing Senate rules, you need bipartisan votes to get to a 60-seat majority. And that requires legislation to at least be acceptable to a significant chunk of the Democratic caucus in the Senate. And even on top of that, I think it's going to be very difficult to get major legislation with purely Republican votes, even in the U.S. House. Even with those vacancies filled, they can only afford, you can only afford 2 defections if the Democrats hold their votes together. And again, I think that will push towards bipartisan lawmaking overall. Now, there is a major exception to this, to the filibuster rule. It's a process called reconciliation, which allows fiscal legislation to go through on a simple majority vote in the Senate. But there are a lot of important limits to the use of reconciliation that constrain its use, particularly in environmental context. First and most important, legislation has to be fiscal, not, for instance, regulatory. So I think it is unlikely you could do major revisions to something like the National Environmental Policy Act through the reconciliation process. Second, you can only do reconciliation once every federal fiscal year. Reconciliation was not used for fiscal year 24-25. So in the next year, through the end of 26, there's 2 opportunities, one for fiscal year 24-25, one for fiscal year 25-26. Maybe 1 or 2 more, maybe 1 more in 26 if they do two reconciliation bills this time around. So that means if the Republicans want to use the tool, you need to compress a whole lot of different provisions into a single large bill, and that makes the negotiating process with a very small majority that much more challenging. So as Dan indicated, it is the case that the climate provisions of the Inflation Reduction Act, those were fiscal measures. They were enacted through the reconciliation process, so they could be repealed through the reconciliation process. I don't know if you have enough votes in the House on the Republican side for broad repeal. There are at least 14 Republican House members who are on the record opposing sweeping repeal of the IRA. That's much more than a 3-seat majority. So I think overall, if you're going to see major legislative action outside of reconciliation, it's almost certainly going to involve substantial Democratic support. That is possible in some issues. There is a bill that just passed in the House with significant Democratic support to make some major changes on fire management on federal lands. And that could get through with 60 votes in the Senate. It's unclear if that's going to happen yet. Probably something with changes will go through, I think. So the most significant changes are going to be in fiscal matters. That could be budget cuts to agencies like EPA, building on sort of the points that Professor Jacobs was making. It could be efforts to pare back or eliminate the Inflation Reduction Act, tax credits for electric vehicles, or various clean energy sources. Again, that requires holding the Republican caucus together in the House, which is a non-trivial task. I think the best reason to think something will happen is there's going to be tremendous political pressure on House Republican measures to do a tax cut, that is, or at least maintain the 2017 tax legislation that they enacted. That is sort of by far the highest priority legislatively for the congressional Republicans. Democrats have 2 additional leverage points that I think, again, will push towards bipartisan policy, legislation overall. So first, if you don't use reconciliation for it, you still have to do appropriations bills through regular order in the Senate, which means you have to go through the filibuster. The appropriations bills for fiscal year 24-25 have still not been enacted. We're under a continuing resolution that's going to end in March. If that doesn't get continued, or the appropriations bills get passed in a bipartisan manner, and if reconciliation is not used, the government shuts down. That will probably not, generally speaking, that sort of is not something that people want to have happen, including President Trump, who was very upset that in December the shutdown, bill appropriations weren't continued longer, and were not, because he thinks he'll get the blame if something goes wrong, which we'll see. And second, even more importantly, the U.S. is going to hit its debt limit in the next few months. And if that's not raised, let's just say the economic consequences could be catastrophic if the U.S. defaulted on its debts. It is difficult for Republicans to pass on a party line vote with that slim a majority a debt limit extension. A number of their members have made clear they're firmly opposed to any debt limit extensions without drastic and probably politically unlikely spending cuts. So debt limit, again, will have to be bipartisan. President Trump, when he was President-elect Trump in December, was extremely upset that the debt limit can debt limit bill did not get extended, and it was going to come due in March. That gives Democrats significant leverage to pursue some of their priorities or protect them, which could include IRA provisions or environmental issues, though they may have other priorities as well. So then what about the next 2 years? What are we going to likely see in the 2026 midterms? Again, lots of uncertainty in politics. I think my baseline expectation is about a 75% chance that Democrats retake the House. And I say that for a few reasons. First, that Republican majority is extremely narrow. It does not require flipping a lot of seats to flip control. Second, I think the general understanding in sort of political science and political analysts is that Democrats tend to be supported now by voters who are more likely to turn out in off-year elections. That is the reverse of what was true during the Obama years, and so that means that sort of, again, a default baseline expectation in those elections is Democrats will do better than you might otherwise, than they will in a presidential election. Third, the president's party generally loses seats in midterm elections. And then fourth, you have a president who is unpredictable, who is not particularly popular in their first term. Voters penalized the Republicans by flipping the House by a significant amount in 2018. If that pattern repeats itself, I would expect similarly a significant number of seats to flip as well. And of course, if the House flips in 2026, then any legislation, by definition, would have to be bipartisan from then on out.
Great, thank you. So I want to turn now to Professor Doremus. I have a couple of questions. We've been focused on energy and climate primarily, but of course that's far from being all of environmental law, as you've reminded me a couple of times, actually. So what about the rest of environmental law? What about natural resources, biodiversity, water issues, oceans, et cetera?
Thanks, Dan, and thanks, Erwin, for pushing us to put this panel together. Because we have only a very little bit of time left, I want to just say a couple of things. I think there really have not been big surprises in what Trump has done so far. We had Trump before. We know he's no fan of the environment. We know he's no particular fan of the rule of law. And he's going to push as far as he can to aggrandize his personal power and the power of those who are most loyal to him at the expense of every other institution in the country. I think so far, Dan said it went through some of the executive orders. So far, what has been totally predictable is the policy whiplash. We had things that Obama had done that Trump undid, that Biden redid, that Trump has now undone again, right? So we've seen a whole series of that. Also, I think entirely predictably, Trump is pushing more aggressively this time than he did last time. He knows more about the ways that the government works. He had 4 years to come up with some ideas and put them in place. Now he just has to redo some of those things. Some of what he's doing, a lot of what he's doing, is bluster. That's who he is. And he'll intimidate people to the extent that he can. Some of it is patently unlawful. Getting rid of birthright citizenship by executive order, that's perhaps the farthest push, but there's plenty of other things. Dan mentioned some of the DEI executive orders. There are places in which through which Congress has actually legislated that there be DEI efforts in the federal government. Trump is purporting to do away with all of those. One quick mention that I saw recently was that the National Science Foundation has a DEI office, which Trump has purported to get rid of, and the person that he's got running the NSF for now has said, yeah, we're getting rid of it. But they can't. That actually is mandated by federal law. So people have got to be looking, don't just accept at face value that he's got the power to do everything he says he does, but be prepared to look and to push back. And we're going to see whether Congress will push back on any of the things that he's doing, whether the courts will push back. They will definitely be asked to do so. I think with respect to natural resources, as with respect to other parts of environmental law, there's a lot of individual things going on that matter and that people need to look out for. But there's also, we can't lose sight of the forest for the trees here. And the things that are going on at the forest level are things like the structural deregulation, if you will, the pushing back on agencies. Trump and the people working most closely with him are not fans of expertise. They don't believe that anybody knows anything more than they do about any topic in the world. And in particular, they're not fans of scientific expertise. And natural resources environmental law, in order to be effective, depends a lot on understanding how the world actually works. So this is an important thing to look at, I think. The incoming administration views science and scientific expertise in particular with a great deal of suspicion. And actually, if any of you have read Project 2025, which Trump, during the election process, really denied, I don't know any of those people, I don't know anything about that. But people like Russ Vought, who's going to run the Office of Management and Budget, were key authors of Project 2025, and a lot of that is already coming in. One of the things I thought was very interesting when I read some parts of that, I confess I've not read the whole thing, there's a section on the Department of Commerce. The National Oceanic and Atmospheric Administration is within the Department of Commerce. And the discussion of NOAA really makes clear what I think is a much more general hostility to science. That suggests getting rid of or drastically downsizing the Office of Oceanic and Atmospheric Research. That's the office that helps tell us what are temperatures, how do they compare to the past, or where are we on this whole climate change thing? And that was described as the source of the federal government's climate alarmism, in quotes, climate alarmism. And the statement is that we really should downsize that because scientific agencies are vulnerable to obstructionism. Think about that. Scientific agencies are viewed as standing in the way of what the president and the administration want to do because these scientific agencies want us to pay attention to the way the world actually works. Other things to look at that are overarching, I mean, the science thing, the other thing that portion of Project 2025 says is that the administration should be really, really careful about who they put in as political appointees in scientific agencies because they really need to rein in and control the scientists. Sharon mentioned the DOJ staffing shifts. I think that's important, and the people, the SES, Senior Executive Service lawyers at DOJ in the ENRD, the Environment and Natural Resources Division, have been pulled and moved to do immigration work. That's telling you two things. One, the current administration thinks its immigration work is going to need a lot of lawyering. But two, they don't want environmental law expertise running DOJ. And I think part of that is they are convinced, and I think probably rightly, that the experienced environmental lawyers at DOJ don't share their view of what policy should and can, importantly, look like. Just a couple of things that are really going to come up. Under the Endangered Species Act, this is the only thing that has surprised me about what Trump has done before. Remote work, really? Were you surprised? He said all during the election he was going to get rid of that. But there is a question whether it's lawful. There are union agreements with the federal workers' unions that say remote work's okay, if it's been approved. He can't undo that by fiat. But the one thing that really surprised me so far is where the executive orders talk about the Endangered Species Act. They say, this is a very concrete thing that I believe they will do, that the God Squad shall be convened at least quarterly. The God Squad is the committee of cabinet-level appointees that it's the executive branch way to allow exemptions from the application of the Endangered Species Act. And Trump has said whether there are applications or not, and by the way, I'm strongly encouraging applications here, the God Squad, which has not met since the George W. Bush administration, will meet quarterly from now on. And I'd watch that. I think there will be a push. I think there will be a push to exempt federal water projects in general from the Endangered Species Act. If that doesn't work, I think there'll be a push to exempt the Central Valley Project in particular, which is the water project that serves California, from the Endangered Species Act. And actually, I think the God Squad would have a hard time doing that lawfully under the ESA. What it takes to have an exemption is you have to show that the project in question is of national or regional importance, and there's no way to operate it in accordance with its statutory goals other than to violate, to do what would be a violation of the Endangered Species Act. But here's one of the places I'm not at all confident that the courts will strongly push back. Another place that I think would be interesting to watch is that the Biden administration, at the last moment, as administrations typically do, withdrew a huge chunk of offshore lands from availability for oil and gas leasing. Obama had withdrawn a bunch. Trump had unwithdrawn, he said, those. And it's not clear. It is very clear that the president under the Outer Continental Shelf Lands Act has the authority to withdraw. It is not clear that the president has the authority to unwithdraw. That was litigated in the first Trump administration, and we only got as far as a district court decision saying, no, you can't unwithdraw. And then Biden was elected and re-withdrew. So we will see about that. Actually, the only place I think that matters, Trump unwithdrew the West and East Coasts. There's not going to be oil and gas leasing off the West and East Coasts because the politics of that remain untenable, I think. But he did also withdraw a chunk of Alaska waters that we'll see about that. But I think I guess what I really want to say about Trump is, and his administration, it's all about bullying. It's all about what can we get away with. And it's about the president versus Congress, the president versus the rest of the executive branch that's not absolutely kowtowing to him, the president versus past presidents, that's this withdrawal, unwithdrawal, and the president versus the states, which was the one other thing that I said I would say. You know, the Trump administration is sufficiently hostile to environmental protection that they are committed to making sure the states don't do it, with California being a key example, right? So they're trying to make sure that California cannot regulate greenhouse gas emissions from cars. They're going to try to make sure that California can't regulate rail emissions, those sorts of things. They want California not to be able to protect California's fish. You know, we're going to see a lot of that there's going to be a lot of pushback against blue states trying to protect the environment.
Okay, I think we're just about out of time. I did, that opened a topic that I wish we had more time for. We saw in the first Trump administration that states pushed back pretty hard against Trump's climate policies. and we may well see efforts along those lines again. I think the Trump administration's general hostility toward federalism is pretty clear in a lot of different places where they're trying to block state actions in ways that hasn't been done before. So I'm sure a lot of that will end up in court. I think that will be somewhat unpredictable. These cases often cause strange alignments among judges. Liberals like national power, but also like environmental regulation or public health regulation. Conservatives don't really like that regulation, but they do love states' rights. And so I think, unlike some of the regulatory issues, I think we'll see some rulings that are not purely ideological divisions from the courts. But I think that is going to be one of the major flashpoints in the next 4 years, is the clash between state governments and the federal government. I wish we had more time. I think each of us could have spoken for an hour about the issues that we've talked about today, but I also know people have to get to classes. So thank you all for coming. This session is being recorded, so if you have friends who weren't able to attend in person, please let them know. They'll be able soon to see it online. And let's wait for the next 4 years. It's going to be interesting. Thank you.